it is an important precedent of the Supreme Court. By it, I mean Roe v. Wade and Planned Parenthood versus Casey. Been reaffirmed many times. Casey is precedent on precedent, which itself is an important factor to remember.
Well, Senator, Casey has set a law in the sense that it's a decision of the United States Supreme Court, right? And you also have Obergefell and Lawrence. Those are all precedents of the United States Supreme Court entitled to Wade precedent, which is quite considerable.
During their Supreme Court confirmation hearings in 2017 and 2018, Trump appointees Justice Gorsuch and Justice Kavanaugh both told the Senate Judiciary Committee that they understood Roe v. Wade and Planned Parenthood v. Casey were the established laws of the land and that they carried the, quote, weight of precedent, end quote, or that they were, quote, precedent on precedent, end quote. But according to this draft Supreme Court opinion published by Politico last night, those cases are likely precedent on precedent for just about another month. While Justice Roberts confirmed the authenticity of the document today, of course, it is still a draft. The language and the justices' votes could still change. But for now, this is what all of those justices I just listed voted for. Quote, we must hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. The provision has been held to guarantee some rights that are not mentioned in the Constitution, end quote. Now, there are several rights that fall into this category. Rights like same-sex marriage, the right to birth control. Justice Alito basically wrote a how-to guide to dismantling those rights, too, which is probably why he also peppered in this tepid assurance. Quote, we emphasize that our decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubts on precedent that do not concern abortion, end quote. That's good. Should we take him at his word? Like some senators took Gorsuch and Kavanaugh at their word? Tonight, the Vice President, Harris, warned that Roe might not be the only target for Republicans.
You know, some Republican leaders, they want to take us back to a time before Roe v. Wade, back to a time before Obergefell v. Hodges, back to a time before Griswold v. Connecticut. But we're not going back. We are not going back.
The president of the NAACP Legal Defense and Education Fund also offered this thought, quote, the leaked opinion suggests SCOTUS has abandoned all respect for precedent and a woman's right to choose. If this is true, we can only imagine what's next and what this will mean for respect for the court itself going forward. Joining us now is Janai Nelson, President and Director Counsel of the NAACP Legal Defense and Education Fund. Ms. Nelson, thank you for being with us tonight. I appreciate your time. And you're an expert to whom we often turn. As a non-lawyer, I was confused by the fact that Justice Alito says the Supreme Court can only protect rights that are, in his words, deeply rooted in the nation's history. So how far does that logic go when it comes to peeling back previously established rights like same-sex marriage, for instance, that are not enumerated in the Constitution? The Constitution doesn't say anything about same-sex marriage.
Yeah, it's deeply concerning that Justice Alito would try to manipulate what is essentially our due process clause in the 14th Amendment in that way. What he's referring to is the fact that not all rights that we enjoy and that we are absolutely entitled to are specified by name in the Constitution. Instead, our Constitution has broad principles. It has the principle of due process, the principle of equal protection under the law. And under those big umbrellas lie important and critical rights that are essential to our freedoms as Americans, our freedom to choose to decide who we'd like to marry, whether that be someone of the same sex or someone of a different race, our right to privacy, our right to determine our reproductive future and our access to opportunity as a result. And what Justice Alito laid out in that extremely disturbing draft opinion is a completely different conception of how this country has evolved over time and treated rights under the Constitution. He talks about rights not being rooted in our history or being part of our view of ordered liberty, without recognizing that the court itself has made those determinations not more than 50 years ago as part of an evolving, progressive, and more inclusive society. So what he did in this draft opinion is attempt to bring us backwards in a way that is not consistent with how we view rights today. It's not consistent with contemporary readings of the Constitution. It's rooted in originalism, which locks us into a period of time in which almost a supermajority of this country had no rights, including most people of color and women and many other groups. So this is really a call for our country to decide what type of constitutional democracy we want to be.
Yeah, I mean, you make a good point. The right for people of color to vote was not enshrined in the Constitution. The right of women to vote was not enshrined in the Constitution. There are all sorts of rights that have come to be, and in this particular case, for almost 50 years. So what is the basis of the argument that it's not enshrined in our history, let alone the Constitution? What does 50 years of abortion protections mean if it doesn't carry any weight with Justice Alito and the majority on the Supreme Court?
What it means, frankly, and it's very difficult for me to say this as someone who leads an organization that put the first African-American Supreme Court justice on the court, and that has won seminal cases like Brown versus Board of Education, using the court to advance society, to help perfect our constitutional democracy. It disturbs me to say that the court has become deeply politicized, and this opinion underscores that fact and makes it, at this point, beyond doubt, beyond cavil, that the court has been co-opted through political a whim and political pressure and power. And I think your opening, where we saw justices claim that this was precedent on precedent, that this was part of their duty to recognize stare decisis, to recognize that when there is settled precedent, that justices on the Supreme Court are bound to respect it unless there is good reason to depart from that precedent. And Justice Alito's opinion, despite the 67-page length plus an appendix, does not provide adequate justification for departing from precedent in this way. This is really an outlandish decision.
Janai Nelson, we always appreciate your time. Thank you for being with us on this important night. Janai Nelson is the president and director counsel of the NAACP Legal Defense and Education Fund.